say you were talking about contempt?
The last call you had, I believe it was last summer, you had mentioned that you were unwilling to do contempt because the D.C. courts were kind of rigged against you. And I don't think that has changed at all. I think you've still got the Silberman sitting on the bench, and we all know that this is something that's going to take years to make its way through, the court system.
Yeah. If I just may, if I gave that impression, what I have said about the D.C. courts are the following. In previous contempt opportunities, for example, when Dick Cheney had closed doors hearing meetings on energy and the rest, and we were trying to get that information, we lost in court on the first try, and we were advised that the next court up, the three-panel court, was not a very friendly court to our issue of the environment, and that we would probably lose, and if we lost, it would establish precedent. The first court didn't establish precedent. It was just an important decision. We didn't get the papers, but it did not establish any precedent that on this environmental issue and the kind of case that it was. I've said on impeachment that I didn't think that we would be successful. That having to do with the Congress, not the court. But specifically on the court and contempt, that particular case, it was judged that it wasn't strong enough to be to prevail, and if it didn't, it would establish a dangerous precedent that they didn't have to give us anything. You're right, nothing much has changed in the courts. We think this is a stronger case because Congress has called for this information. Usually somebody even just shows up and says, we're not coming. We're not coming to testify, or we're not bringing the documents you want. But this was really completely ignored the system of checks and balances and the prerogatives of the Congress of the United States.
Will you follow this through the change of the administration if it's still in the courts at that time? And would you consider why didn't you guys consider inherent contempt, using your own powers to compel people to appear?
Well, you mean arrest them and put them in a little jail cell that is in the basement of the Capitol?
Sure.
Here's what we did. Let me make you clear about what we did. As you know, the Judiciary Committee, subcommittee, then full committee, passed out a citation, contempt of Congress. We took that up with a big, strong vote. I was very, very proud of our Democratic vote on it. I was actually disappointed in the Republicans, not disappointed because my expectations were high, but disappointed because this is contempt of Congress. This isn't partisan. This is clear that they are not giving us what we are asking for, and that means they're not giving the American people what they need to make certain decisions. And so this just said, crown me king, because I don't have to answer to Congress. So we sent that citation to the administration. Last week, Attorney General Pelosi ordered the U.S. Attorney for the District of Columbia not to enforce the congressional subpoenas against Harriet Miers and Josh Bolten. You know that. In response, I have been consulting with the bipartisan House leadership, and I intend to authorize the House General Counsel, Irv Nathan, to file suit in federal court to seek enforcement of the subpoenas. We're taking this action to protect the rule of law, our constitutional system of checks and balances, and if Congress cannot compel testimony, it cannot conduct its oversight and lawmaking responsibilities. It's that simple, and they know it. I know, though, I just said this at a press conference. In the dissenting views on our original contempt charge, 17 Republicans in their dissenting views, 17 members of the House Judiciary Committee, went on record with an alternative to contempt. That alternative would be to bring an enforcement action under the federal questions jurisdiction already conferred on the district courts.
So will this action survive the administration if it's still in the courts? Well,
I would hope that there would be a resolution of it before then, because there's lots of information we want from the administration. That the origin of this is something you're very familiar with, the politicizing of the Justice Department. So it's the Justice Department making decisions about the politicizing of the Justice Department, and why the U.S. attorneys were fired and why some of them stayed. What did they do to be able to stay, and what did the others do? Well, let's focus on those who were fired. And so we believe strongly that the record is clear on the subject. This is not executive privilege. They even admit that many of these conversations did not involve the President of the United States. But what we're asking for did not involve the President of the United States. So that's the case that we'll have to make in court. And you have to be careful on these, because you want to go in with your strongest case, because as we know, these judges appointed with a different philosophy, perhaps, of separation of powers. Let's hope that they all honor their oath of office to support and defend the Constitution of the United States.
But if the court cases do get extended into 2009, you can't tell us right now that you will continue to prosecute the subpoenas?
Absolutely.
You will. Excellent.
Absolutely. This is about the Congress of the United States, and we can't say, well, it was important when we had a Republican president, and it's not important when we have a Democratic president, because, it just isn't the case, A. And B, even if you thought that, what does that say for the future?
Right.
I mean, we might as well shred the Constitution or forget about taking the oath of office if we're just going to do it for a Democratic president or a Republican president, not a Democratic president. Same thing with FISA. On FISA, I don't want a Democratic president having the authority that George Bush wants, and I don't want a Republican president having it. They shouldn't have that authority, period.